Welcome back to You Can't Say That in Court, a podcast by Rise Women's Legal Center. I'm Vicky Law.
And I'm Stephanie Melnick. We are your hosts as we continue this conversation about survivors of violence navigating the BC family law system. We recognize that the legal system we have in BC is colonial and causes harm to families, which disproportionately impacts Indigenous people.
By speaking openly about these harms, we hope to raise awareness about the challenges survivors face as they navigate the colonial family law system. Our podcast is an attempt to collectively identify the barriers and advocate for positive changes to be made. Thank you for joining. Our podcast series will discuss difficult topics such as gender-based violence and intimate partner violence. This includes physical, sexual, emotional, psychological, and financial abuse. Please be aware that this is a thread that is woven throughout all the episodes, and we hope you will take care of yourselves however you need.
Hello, everyone. This is You Can't Say That in Court. And today we're going to chat about some changes that are happening in the court system. They're smaller changes and they're a bit slow to come, but it's overall very good news. So Vicky and I are excited that we're going to be able to talk about addressing one of the barriers that survivors have in going to court, and that's having to choose between or being forced to do either a hearing in person or whether they can appear virtually. So this was a recommendation that we made in the report that we published back in 2024, and we'll link our report, which we've talked about before, in the show notes again. That's the Building Inclusive and Accessible Family Justice report. So yeah, we're just going to get into what this method of appearance problem looks like and how some possible solutions could come up.
Yeah. So when we talk about court hearings, usually I think a lot of people think about like the movie where there's a jury and there's two lawyers, and there's witnesses, but not all court appearances are like that. There's some that are much shorter. There's some that are called conferences, which are more conversational with the judge. So not all court hearings or court appearances is what you see on TV, and it's not always argumentative, even though court is it's litigious and it's what's the word I'm looking for?
Like combative or confrontational, or
Yeah,
are you thinking?
The word's missing right now, but you know
It'll
what
come
I mean,
back.
Stephanie.
Yeah, I
Yeah.
know what you mean. Yeah. Also, that in BC we have so many circuit courts, and so there are all kinds of reasons why someone might not be able to or to show up in person for one of the different types of appearances, like you were talking about. Definitely the shorter ones. That is much more of a problem, to have to drive long distances or whatever it might be. But
And to wait in court for your matter to be called.
Yes. We're going to be echoing back to a lot of themes from previous episodes, because some of these barriers are the same, but in kind of a different context of actually having to go to a courthouse.
Yeah.
Yeah.
So, well, maybe we'll just start from like the beginning, which is like, when did court become virtual? And I think
Yes.
it really became more popular during COVID several years ago out of a necessity. Previous to COVID, there were court appearances that you could do via teleconference, and oftentimes you had to apply for it. And it's really funny because when I tell the story of how the virtual legal clinic started at Rise, it started before COVID. But one of the steps that you and I were, that I was planning on doing was teaching everyone how to use Zoom. And then March 2020 hit, and I was like, okay, everyone use Zoom now. We don't have to show everyone where the mute button is or how to turn the camera on. Let's get on with it.
Exactly.
So virtual appearances really became more common because of COVID, and the need to stay in our homes.
Yeah, it was interesting too during our research learning about some of the problems with virtual appearances for yeah, for people who were attending court that if they had really bad technology, unstable internet, or in some of the more rural parts of the province, they don't have, yeah, that kind of accessible connectivity either,
Mhm.
or a private place in their home where they can actually engage in a court appearance without other people overhearing that they don't want. And so that's where we kind of came around to the position of it depends on someone's specific set of needs. And so just having the choice between attending in person or attending hybrid, attending virtually, having that hybrid default was the best way to go. And then each person for their own specific circumstances can choose what they prefer. And this was especially important for people who are attending court without a lawyer, because generally lawyers are going to be used to appearing in person. They're going to be trained and conditioned that this is
Mhm.
the more formal way to conduct court proceedings. And lawyers have the benefit of not taking time away from their jobs to attend court, so it's not as much of a barrier in most cases. So yeah, it was kind of interesting to learn about the downsides of both types of appearances. But I really do appreciate how the courts ramped up virtual appearances during the COVID period because they really did mobilize quite quickly for,
Mhm.
a slow moving kind of organization.
Hmm. And I think the court and a lot of the users, lawyers, judges, court clerks saw the benefits of attending virtually, and so they've kept it going now.
Yes,
So a lot of the court appearances in both BC Supreme Court and BC Provincial Court are default especially in provincial court, are default virtual. So the
right,
automatic method of appearance is through Microsoft Teams. And I know that's a barrier as well. Like a lot of people you and I spoke to, Steph, talked about how just Microsoft Teams just wasn't user friendly
right.
because they don't use it day to day like a lot of us do who we need to use it for work. And
Hmm.
when you only have a court appearance once every several months, it's hard to log in, not knowing what's happening. And I think more people are used to it now. But I do recall at the beginning there was a lot of confusion about
Yes.
what
Yeah.
was happening in court because all these people were waiting.
Right.
And you saw a long list of people you weren't sure who was whom.
Right.
Yeah.
Yeah, I also know there was some anxiety early on before it became more routine because uh, court users who were attending their own hearings virtually weren't driving to the location to be there physically in person. And sometimes they could be like more than an hour away. So if they had
Mhm.
somehow mistaken that they were supposed to be on MS Teams, they couldn't then be there in person very quickly. And I know there was a lot of anxiety, like, am I really supposed to just stay home and sign into Teams and trust that
Yeah.
this is going to work and this was the right thing to do? And then there were even some kind of situations shared through support workers saying that some people prefer to go to court, be there in person, establish credibility with the judge because they're a survivor of violence. They want to be able to tell their story and be
Mhm.
believed and be heard. And they found that that was maybe more compelling to do in person. That's not everyone. There are
Mhm.
lots of survivors of violence who really feel more comfortable being able to attend court from their home through MS Teams because they have a bit of
Mhm.
a distance from, say, the abusive opposing party or whatever it is. But some people prefer to be there in person and just be like, this is me, this is what's happening for me, and feel like they make a better connection being there in person.
Yeah. And I think there's also a benefit to having in-person support, right? Whether that's
Yes.
through the court staff or through sheriff or through support
Yeah.
pers people. Um, Having that in-person support is just way more beneficial than staring at a screen.
Right.
Um, it's hard to have a support person virtually unless they're also appearing virtually with you next to you physically.
Right. Right.
Um, a lot of support people provide notes to the court user if they're unrepresented.
Yeah.
remind them of certain things that they need to do, which can be difficult to do in a virtual setting.
Yeah, absolutely. You're right. It can be very validating for a survivor to have a sheriff or a victim service worker or someone like that
Hmm.
say, yeah, I'll meet you in the parking lot and I'm going to accompany you all the way to the courtroom because you deserve safety and protection. And we recognize that there's something unsafe about this situation. So, yeah, that validation piece doesn't happen if you're appearing over like virtual means.
Hmm.
Yeah. So, yeah, I was going to say a lot of the overwhelming information that we heard from support workers, though, was that there are more barriers to attending in person, especially if they're like it's a short appearance. So, say it's just, yeah, something to confirm the date or make sure that
Hmm.
disclosure had been shared or whatever it is, just one of those smaller types of court appearances, then figuring out transportation to get there if it's a long distance to the court location, having to take time off work, and generally taking the whole day because you don't know when the matter is going to be called
Yeah.
necessarily, especially for family matters on a mixed list. Needing childcare, all those sorts of things are really huge logistics that have having virtual appearances for some of these smaller um, types of appearances has been really helpful. That was kind of the overwhelming thing that we
Yeah.
heard.
Yeah. And I think based on our recommendation, which was to have it a hybrid so that people can choose, I think goes back to our colleague Haley's report on creating safety and also our report in 2024 about that it's more trauma-informed approach. Like
Yeah,
having the survivor, having the court user choose how they want to appear gives them back the ability to decide for themselves what's best because everyone's
right.
circumstances are different.
Right. Yeah, you're right. It is more trauma informed, recognizing that everyone is different and that they're going to want to choose from all the options that the courts can provide, however many that might be. And certainly at this point, there are lots of situations where the courts are like, nope, this has to be in person. There's no flexibility on this yet. But oh shoot, I just lost my thought. It was about the being trauma informed in having a choice. It's been really hard for, I think, the courts to recognize that not creating that extra step of an application is a big
Mm.
barrier. You know, the courts are like, well, it's been there for a while. If you need to appear virtually, no problem, make the application. But for self-represented people, people who don't have a lawyer, that's just one more application that they need to figure out for time limits and making sure that the registry will accept it, and then having it heard and a decision be made on it. It's just another hurdle. So I think from that like trauma informed lens, having a default of hybrid where you don't need to make an extra application for whichever way you want to appear. You just always have a choice. That's the important part about it.
Yeah. I think the application again also just leaves it up into the air, right? Because if
Yeah.
let's say the default was in person and the court user applied to appear virtually, they're waiting for that decision to be made
Yeah.
whether that's allowed or not. But
Yeah.
for someone who needs to take 2 days to travel to a courthouse because there's ferry involved and driving and
Right.
all that scheduling, that takes planning and that takes some time to work it out, taking time off of work, finding childcare, et cetera, et
Hmm.
cetera. So oftentimes I think court users and survivors are just doing that calculation. It's like, do I risk it and make this application in hope that, it's successful and I can appear virtually? Or should I just make all the plans and just appear in person because um, that's something that I can control and decide and plan for right now.
Right. Yeah, exactly. And I think what's maybe shifted a little bit in the legal landscape generally is just an overall shortage of family lawyers.
Yeah.
So more people are appearing in court unrepresented. And if someone had a lawyer, then that lawyer would be keeping an eye on the whatever the hearing was or the appearance coming up, and they would say, "Hey, we're kind of at around the time that we should make an application for a virtual appearance,
Mm-hmm.
if that's what you would like." There'd be someone there, kind of looking at the time limits, and then having the professional understanding of how to make the application, how to make a compelling argument for it,
Mm-hmm.
and be able to lay out the expectations. And so
Mm-hmm.
when people without lawyers are navigating the system, I agree, they're probably not bothering to make that extra application. And so
Yeah.
whenever the courts are able to say, okay, under these circumstances, the default method of appearance is a hybrid. You just get to choose without making any extra application. And they just provide the Teams link and they're ready for the person to show up in person, like that all works. I think that's really helpful, especially for the people who are navigating without lawyers.
Yeah. And there's also a ton of applications, court appearances, where if you do have a lawyer, the party does not need to attend. They
Right,
just need to be available for the lawyer to contact them if something comes up. But
right,
there's a
right.
number of court appearances where if there's counsel on the file, then the lawyer attends, and that's sufficient.
Yeah.
But I just want to recognize that our recommendation about making it a hybrid model does put more work on the court system, right? It
Oh,
requires
yes,
the
yes,
court system
absolutely.
and the court clerks and everyone involved behind the scenes for to make
Yeah.
court happen. It does require more logistics on their end to make it efficient, to make
Hmm.
sure that the options are available, but it's not impossible. So I just want to
Right.
recognize that it is more work, and it is more work to make the courts more accessible for everyone who's using it.
Yeah, I think that's a good point because there have been changes in the last couple of years, both at the provincial court level and the Supreme Court level. And so recognizing that that's not the easy thing for the courts to make that shift. Um, I think they're listening to the fact that, their own statistics are showing that there are more unrepresented people in court. And so it's responding to
Hmm.
that, trying to provide some flexibility or some accommodation for people not appearing with lawyers. But it's also just listening to what's changing in the landscape. And yeah, so it's more work for the courts to do that, but they're responding to what people need, which is a good thing.
Hmm.
Yeah.
Yeah. So we have um both levels of court making very recent changes actually to
Hmm.
the appearance method, and there's some really good things coming from the courthouses and piloting certain ways to attend court or filing documents, which can be less of a burden. But I think Stephanie and I would just want to highlight again that, like, submitting an application to change the default way of appearing is it hinders access to justice and it hinders efficiency. There's a lot of time and burden placed on the court users.
Yeah.
And at the end of the day, especially for a survivor, the court needs to consider the position of the other party, who for a lot of our clients are abusive, and so um, oftentimes we don't get opposing parties agreeing to what our clients are seeking for.
Right. And that's actually something we hear a lot of. The why would I even bother applying? Because he's just going to oppose it as a matter of practice. It's just like,
Hmm.
You know, I say yes, he
Yeah,
says no. It's just going to be the way it
yeah,
is. He's not going to make accommodations or be reasonable necessarily if the opposing party is abusive and is using the legal system to make things harder, then making the application is not realistic. So yeah, that's
yeah.
that's one of the pieces that we were trying to highlight was making the default a choice without any additional applications is really important. But we know that that can't be the case for every kind of hearings. So the fact that
Hmm.
we're just starting out and that both levels of court are changing some of these defaults is good. I hope they continue doing that. That would be really helpful. It's interesting when they choose to make something default hybrid, like the Supreme Court has done that with a
Mm.
couple of different, very specific types of appearances. And they're like, okay, the default is now going, sorry, I misspoke, not default hybrid, default virtual.
Hmm.
That they've decided, okay, now this is going to happen virtually and exclusively it's going to be through
Hmm.
MS Teams. Because, yeah, going back to one of your earlier points, that's not necessarily going to work for everybody. So it's not responding to the court user's needs specifically, but it is a change. It's a deliberate change to try and make things easier somehow. And I mean, to be fair, these are the smaller, less consequential appearances where there doesn't need to be evidence presented and that kind of thing. They're meant to be a little more straightforward so that things can be done quickly and efficiently through Microsoft Teams. Um, but again, if you're a person in a more remote area of the province or just have unstable internet or don't have updated technology that's working properly, like your laptop or whatever, then having that default is a problem. So I hope that all those people in that situation can connect to maybe a community-based worker of some kind who has resources at their office who can help set them up so that they can meet that default virtual um, option. Yeah. It's an
Yeah.
interesting shift for the Supreme Court.
Yeah. And I think the provincial court has some default hybrid for certain
Yes.
appearances. So
Yeah, they do.
that's promising. And I know that the courts are taking other factors into consideration when considering an application is made to change the method of appearance, such as travel, the traveling distance, cost, health, accessibility,
Right.
safety concerns. So that's really great to see. And I think that, as technology is improving, our court system are also improving along with it. So it does make it easier at times to navigate the court system,
Yeah.
especially for lawyers who now they may not need to wait, the entire day for their court matter to be heard. There's still
Right.
some of
Yeah.
that happening, but it's less.
Hmm.
And I also just want to clarify that Stephanie and I are not proposing that all forms of court appearances should
Right.
be hybrid.
Right.
There's definitely some that do still need to be in person, like such as
Yeah.
trials. Like I can't imagine doing a multi-day trial in
No.
a virtual setting. That might be a
Yeah.
bit chaotic. So
Yes,
so just
exactly.
yeah, want to clarify that there are certain types of court appearances where a hybrid model would be best. And
Hmm.
I think we're hopeful to see these changes being made.
Yeah, absolutely. And it does feel like the courts are moving forward cautiously, step by step. And I think that's the right way to go. Just
Yeah.
continuing to add very specific types of appearances as they see that it's working well with what they've already said could be
Hmm.
hybrid, where people get to choose, and then adding to that slowly over time, I think, or a
Hmm.
little, maybe a little quicker over time, but step by step. Yes, makes sense. And I'm really glad. I feel like this is going in the right direction. So it's kind of a positive note that we're ending on.
Yeah. And I do think maybe sometimes like it may not need to be applied universally across all the courthouses, right? Like if certain, like for example, the
Right.
circuit courts want to try something, or certain
Hmm.
locations in more rural and remote communities want to try out something, like um, they should do it.
Yeah.
And we're encouraged to see that.
Yeah, well, and I'm especially happy to see the Supreme Court getting on board as well, because that is, I think, the accessibility and the barriers exist a lot for people who can't access. If they file at the Supreme Court, then they have to
Yeah.
go to the main staffed location rather than their local circuit
Yes.
court. And that is what creates so much additional burden to actually get there in person. So, yes, very
Yeah.
encouraging across the board. Um, yeah, and hopefully it just continues from here.
Yeah. So we're excited to see what is coming still, and hopefully it will improve and increase access to justice for all court users, knowing that we still have so much more to do.
Yes.
And that's it for today. Thank you so much for joining us, and we'll see you soon.
Thanks, everyone. Everything that we have said today is not legal advice. If you or someone you know needs legal advice, please consult with a lawyer.